session. As we do it on Tuesday, we'll have property matters brought to you by Accent Reality as supported by Accent Radio. My name is Destiny Unoati Ichebo, and I will be your facilitator for today's session. So today we're going to be looking at a very critical topic, breach of contract. That's what we'll be looking at today. So our topic for today is property transactions, remedies available to parties where there is a breach of contract. So our topic today again is property transactions, remedies available to parties where there is a breach of contract. So we're going to start with a little story, and our story for today we have just two characters, the main characters. Now there is one Mr. Ose Jibo and there is another Mr. OJ, who both entered an agreement, and the agreement states that okay, Mr. Jibo is going to pay Mr. OJ a certain amount of money over a property, and the part is that okay, Mr. Ose is going to pay this amount, and once Mr. OJ receives the money, he's going to give his property to Mr. Ose. But it happens that after payment was made, Mr. OJ failed to deliver the property to Mr. Ose as already arranged. Now, the thing is, what can Mr. Ose do in this circumstance? Is he going to let the money that he has paid to Mr. OJ go just like that? Is that going to be this case? No, but that's what we're going to be looking at today. What are the things that Mr. Ose can do in the circumstance that Mr. OJ fails to give him the property as already agreed, having made payment? Now, what is breach of contract? A breach of contract refers to failure to perform the acts as agreed under a contract between two parties. That is, a party to a contract has performed its own part, but the other fails to perform its own part. There are always covenants or agreements that are settled under any contract between two parties. Now, one part of the contract is that whoever is purchasing the property has to pay certain amount, while the other part of the contract states that the seller has to give the property to the buyer, and those are the major terms in any contract of sale. But when there is a failure to perform a particular act, maybe the purchaser fails to pay the full amount of the contract, or the vendor, having received the amount, fails to deliver the property to the purchaser, then there is a breach. So that's when a breach arises in any contract or sale. Now you may want to ask, what forms do this breach take? Now, majorly there are four common forms of breach of contract. So we'll be looking at them one after the other. So let's quickly list them. One, we have material breach. Then the second one, we have minor breach. And the third one, we have anticipatory breach. Then the final one has to do with actual breach. Now, when you are talking about material breach, what do you mean? So material breach is that breach which has to do with the actual performance of a contract. That is, when there is material breach, it means the contract can no longer have any effect. It cannot be concluded. So there is no way the contract can be performed because that particular act has been done by a certain party. For instance, a vendor decides that, okay, I want to sell a property. He tells the purchaser that I have 1,000 square meters of land situated around Ikeja. Now, the purchaser pays the purchase price to the vendor. But at the end of the day, after making payments, he discovers that the vendor only has title over 400 square meters out of the 1,000 that was sold to the purchaser. That is a material breach on the part of the vendor. It means he has no title to the 1,000 square meters he has told the purchaser that he has title to. So if he doesn't have a title to the entire parcel of land which he represented to the purchaser that he wants to sell, that is a material breach. It means the contract cannot have full effect. It means it is impossible for the vendor to perform his part of the contract, which is delivery of the plot of land or the parcel of land to the purchaser in this respect. That is a material breach. There is no way the contract can be fully performed by either party. Now the other one is minor breach. This is a breach that occurs where parties can still go on with the contract. It's something minor that either party can overlook. Whoever is affected by the breach can overlook it and go on with the contract. Example is when there is late delivery on the contractual terms. For instance, the property transaction states that Mr. A is to deliver the property to Mr. B on or before the 31st day of January. But it happens that due to some circumstances, he was only able to deliver the property on the 1st of February. Now, if Mr. B finds that, okay, he failed to deliver as had agreed on that 31st of January, does it really affect my rights so much that it will require me to get damages? No, if you find out that, okay, because of the nature, it's just a day difference, I will not be needing to go on to bring action against this person. It means it did not affect the heart of the contract, it did not affect the performance or the enjoyment of the benefits which accrues to the purchaser in the agreement which they have both entered. On the other hand, the vendor, maybe the purchaser agreed to transfer the purchase price to him maybe 2 p.m. on a Friday, but ended up sending the money maybe, let's say, 11 p.m. Does it affect the transaction in its entirety? No, it's just a minor breach. It's something that can be overlooked by either of the parties. Now, if that is the case, it means therefore parties can still go on with the contract as it does not affect its performance. Now, the third one is anticipatory breach. It means it has not happened yet, but there is great concern that there is a chance that either of the parties is going to breach the contract. For example, you have gotten information that Mr. A, you just purchased a property from, has put up the property on sale to, let's say, Mr. C. You, as the purchaser of the property, you are Mr. B. You already paid purchase price, and you have seen that, okay, Mr. A is going to sell this property to Mr. C. That is anticipatory breach. That is, there's a possibility that Mr. A is going to sell to some other persons. What can make you believe so? Maybe after you have already inspected the property, you have made payments. He takes another set of persons to that same land that he has already sold to you. Maybe you have an informant. They will tell you, okay, Mr. B, I'm just giving you this information. It's confidential. Mr. A is likely to sell this lot of land to Mr. C. Then you can say, okay, it's an anticipatory breach. Though he has not sold the property already, but there's a chance he's going to sell that property to someone else. And if he sells that property to someone else, it means you are going to have long legal battle to recover that property, and you wouldn't want to go through that. That is anticipatory breach, because you anticipate that he's going to breach that contract. Then you have the actual breach, which is the fourth one. Now, how does this relate to you? It means that the person has actually done an act which is contrary to the terms of the agreement, unlike the anticipatory, which suggests that it is likely to happen. Under actual breach, it means it has happened already. It therefore means if, for instance, the example we gave under anticipatory breach, Mr. A has sold the property to someone else already. You know, the practice, the sharp practice that is done in property transaction, you find a vendor selling one property to 3 different persons. Sometimes you have 4 different persons fighting over a property. Mr. B comes, tells you, I purchased this property from Mr. A on 1st of February. Then Mr. C comes, he tells you he purchased that same property on the 5th of February. Then Mr. D will come to tell you that, okay, I also purchased this property on the 16th of February. All of them purchased February 2022. So it means there's actual breach. Mr. B, who purchased the property first, can no longer take possession of the property because some other persons are also claiming title over that same property. That is actual breach. You can always seek remedies when this happens. Now, we'll go into the remedies available to each party when there's a breach of contract, bearing in mind the 4 categories of breaches that could occur. If you are seeking remedies, it means your remedies must come under any of the categories of breaches that may happen depending on facts of each case. So what causes a breach in Mr. A's case may be different from what will cause a breach or constitute a breach in Mr. B's case. Now, what are the remedies you can seek when there is a breach of contract? Now, the first one is to seek damages. Now, the damages is also available when there is a breach and monetary compensation will be available to you or will be sufficient when you are calculating your losses. Let's say, for instance, you purchased a property from Mr. A, and at the end of the day, you discover that, okay, a part of the plot which you have purchased has been encroached upon by the same Mr. A, and you want to retain the property. You can say, okay, because I paid so amounts, I want this to be given back to me. That is, you can be compensated with money. That's when you seek damages. Where the breach has occurred, you cannot get sufficient compensation with the money. It therefore means you cannot come under compensatory remedies. Now, another instance where you can get damages is when in the performance of the contract, maybe Mr. A, you have already entered the contract, he decides to pull out of the contract. At the point of execution, you have done everything that was required of you under the contract. He has also performed to some extent, but he decides that, okay, I don't want to continue with this contract again, with no justifiable reason. Then you can as well proceed to court to get remedies. The remedy you can seek under here is compensatory damage. But if you find that getting a monetary compensation will not be enough for you, then you cannot be seeking for damages in the circumstance. So you must ensure that what you are going to get, money can compensate you. If money will not be sufficient, please don't come under monetary damage. What you can do, however, is to seek monetary compensation and other reliefs, which we'll be discussing subsequently. Now, another thing you can also do, if it happens that you are the vendor, but you find out that after you have done everything that was required of you, the purchaser decides to back out of the deal. You have done everything. Maybe he told you you have to get title, you have to do this, you have to do this, and you have done all of these acts. And at the end, he tells you, okay, I have seen another property which I now want to purchase. You can also bring an action against him. But what you have to say when you are bringing this action is loss of other potential buyers. It means what you are saying here is that there are other persons who were interested in property or who would have been interested in purchasing the property. But because Mr. B showed sufficient interest that, okay, he has shown to everyone that he's going to purchase the property, then other persons backed off. Now you have to bring action against him for damages, for making you lose clients who would have purchased the property from you. That is for the vendor. Now, another remedy that is available to you as a party who was wronged in the property transaction is to get an order of specific performance. Order of specific performance. What do you need this order for? It means there is an act which you want to compare the party who is in breach to perform. Let's say you have already agreed on what is to be paid and everything, the money has been paid to the person. It happens that before delivering title to you, something happens to the vendor and he was unable to transfer title to you. He has already received money. Let's say situation of death, the vendor died in the course of execution of the contract. So you can bring an action compelling the members of the family of the vendor to transfer title to you, having paid what is required of you under the agreement which you have entered with the vendor. So you must also show to the family that, okay, this is the extent to which we have transacted, and they acknowledge the fact that, okay, we know that you have been transacting with this person and he has told us that he has entered such transaction with you. Then you can get an order to make them conclude the transaction. Without getting an order, they may not be ready to continue with you because they may want to bring in their own terms into the contract. So you can always bring that up in court. Another remedy that is available to you is rescission of contracts. You can, okay, because this particular person has failed to perform his part of the contract, then you can say, okay, I'm not continuing with the contract because you have breached some terms of the contract. Let's say you are the purchaser. In this circumstance, the agreement is that the person must have good title to the land, and you discover at the end, maybe in the course of search, you discover that a part of the property does not belong to the vendor as he has represented to you, or it happens that, okay, the person shares interest with some other persons, or he does not have title at all. Then you can rescind the contract. Whatever performance you have done in course of the contract, you can always bring an action for damages if you have spent money. Then you can say, okay, because he doesn't have title, I cannot continue with the contract, therefore I am pulling out. Then if you are the vendor, you can also pull out of the contract where it happens that the purchaser made a deposit, but he has failed to pay the balance of the contract. You can say, okay, because you have failed to pay within time, then I have rescinded the contract. I don't want to continue with the contract because you have breached the terms of the contract. That is an option that is also available to you. But before you can do this, you have to ensure that the purchaser has failed to make payments as agreed by both parties. Then the other option that is also available to you, that is another remedy that you can also get in court, is declaration of title. Now this is applicable where you have shown sufficiently, okay, you have performed your own part of the contract and other persons are also claiming title to the property. You can go to court and let the court declare that, okay, because you are the first person to purchase a property and you have done every act that is required under the law for a purchaser to do, then you can also go to court for them to declare that you are the true owner of the property. Sometimes vendors will want to make troubles with the purchaser after they have sold property. They will want to either they want to sell at a higher price because they have seen someone else and the person has actually made substantial payment to them just to make sure that they have the property. You can go to court and seek declaratory relief to make the court hold that you are the actual owner of the property, having performed all that is required of you under the contract. Then another remedy that is available to you is to get injunctive relief. Now, how does this work? When you are talking about injunctive relief, you are saying that, okay, you want to stop or prevent any person that is trespassing on the property. It could be the vendor, it could be his agent, his assigns, or those who are claiming under him, under any means, who are claiming under him. They could be the ones who are trespassing into the property. Then you can get an injunction. It could also be that the property, what you have purchased the property, maybe you want to build residential apartments on the land, but the vendor has done something or is going to do something on the land that will prevent you from using that property for residential purpose. It could also be that you want to use the land for the purpose of agriculture, but you are seeing that the purchaser or someone else is doing something on that land, maybe raising a building or pouring concrete on that particular portion of land or any part of the land, and at the end of the day, that particular thing that has been done on the land will prevent you from using that parcel of land for agricultural purpose, then you can go to court and seek injunctive relief, preventing them from doing or continuing that act which they are doing or they want to do on that plot of land which you have also purchased from them. The another thing is forfeiture of deposits. This is only available to the vendor. Like I said earlier, when the person who the purchaser has failed to perform his part of the contract by making full payments. Now, if it happens that the purchaser has paid some amount, let's say the property transaction cost 50 million, and the person, because he wants to show that he's committed to buying the property, decides to drop 1 million. Then after some months, he has failed to do any further payments to you, then he can forfeit maybe. But however, before you can enjoy this this remedy, you must ensure that you have an agreement to that effect, that if he fails to complete payment within so time, he stands to forfeit whatever payment he has made before that particular date. So if you have that on ground, then you can make him forfeit whatever payment he has made as deposit. But however, you must ensure that the amount is not so huge that it will be unreasonable for you to make the purchaser to forfeit whatever he has paid to you. Let's say the property transaction cost 15 million. The purchaser has already paid, let's say 7 million or 8 million to you. And because you have that clause that if he fails to complete payment within 2 months, he is going to forfeit the deposit that he has made. The court will not allow that, because that would be a grave injustice when the person has already paid half or more than half of what the property will cost. So you may not be eligible to enjoy that particular remedy that is available to you. Then you can also recover deposits if you are the purchaser. You have made payments, huge amount of money. You have committed it to the property, but maybe in the course of search or further search, you now discover that a part of the property does not belong to the vendor. You can decide to recover whatever you have paid to him as deposit for the property. You can say, I don't want to continue with this transaction again, because certain things which you ought to do, you will be unable to do it because of some circumstances that surrounds the transaction. So if it's impossible for you to continue with the transaction because of the things that the vendor has done, therefore you can proceed to recover whatever amount you have deposited for the completion of the contract. But you have to note that not in all cases that you enjoy these remedies. There are circumstances where it is impossible for the vendor to continue with the performance of the contract. For instance, there is war. You have already signed a contract. Because you have signed a contract that Mr. A has to deliver a property to you at a particular house or a particular street and a particular point in time, there may be some intervening factors like war, riots, and other acts of God. If any of these is a situation that has occurred, you cannot compel the purchaser or the vendor to perform a particular act, which is legally impossible for the person to do at that particular point in time, because some things may have happened. Let's also have another instance where, due to heavy rainfall, there is a collapse in some parts of the building, maybe because you didn't do certain things, the nature of the land, or it's an agricultural farmland. There was heavy rainfall, and because of that, there was erosion. Erosion swept most of the things that were already on the land. You cannot bring an action against either of the party that, okay, because this has happened, there is a breach and I want to get a remedy. No, you must consider what transpired in each of these cases before you can validly bring an action for any of these reliefs that we have talked about today. Now, in summary, whenever there is a wrong, there is always a remedy. If you believe that the vendor has breached a fundamental term of the contract, or you believe the purchaser has breached the terms of the contract, you can always seek relief. Try to see how any of these breaches has come under the 4 categories of breach of contract that we have listed. Also try to see how you can relate the remedy that you can get from court to any of the remedies we have also listed before now. And also try as much as possible to see that you bring an action within reasonable time. Because if you fail to bring an action within reasonable time, you may not be eligible to enjoy any of the reliefs that you want to enjoy. It may be deemed that you have waived your rights to get those reliefs. Therefore, you have to ensure that you bring this action at the right time. That's how far we can go today. I thank you for being a part of this conversation. Join us again next week where we'll talk about some other topics that will interest you. I remain Destiny Untitled. Follow us on all our social media platforms to get more of this discussion. You can be part of the conversation. You can always ask questions, and we'll be ready to listen and attend to you. You can send us an email, info@lawassent.com. We'll respond to you almost immediately. Thank you again.